give them to my judicial assistant. She will destroy them. That's one of her favorite jobs, especially compared to the other things that I give her. And no one will ever read your notes but you. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. So if you can write your name nice and big on the first page, and then if you do want to take notes, you can start on page 2, and that way if anyone sees your notepad, they'll see your name there, and they'll know that it belongs to you and it doesn't belong to them. All right, any questions? Mr. Schaub, you may proceed with your opening statement.
You need to stop this behavior. You need to knock it off. It's not worth it. I can't help myself. It always gets me in trouble.
Objection, Your Honor, argumentative, and it's not a statement of what he intends the proof to show. He hasn't indicated that.
Overruled.
Those are the words of the defendant on February 14th, Valentine's Day of last year, when he got into a parking lot altercation at the Circle A convenience store in Clearwater. Those were his words. 5 months later, those words rang true. Because on that day, he got into another parking lot confrontation with a young African-American female named Britany Jacobs. And her partner, her boyfriend, the father of her 3 children, came to her aid, and he did not drive home that day. As he found himself dying on the floor of that same convenience store 5 months later in Clearwater, Florida, as his 5-year-old son looked on. Good morning. Yesterday, the day before, we had an opportunity to ask you all a lot of questions. Well, today there should be 2 questions you have of Mr. Rosenwasser and myself. What are you going to prove to us, and how are you going to prove it? What we're going to prove to you during the course of this trial is that the defendant in this case is guilty of the crime of manslaughter. Now, we've watched a lot of TV, we talked about that. We've heard about, premeditated murder. No, he's not charged with first-degree murder. We've heard about ill will, hate, spite, evil intent, second-degree murder. No, he's not charged with second-degree murder. What he's charged with is manslaughter. He took the life of another human being unlawfully without any legal justification. And that's what we're going to prove to you during the course of this trial. Now, how are we going to prove it? 2 ways. By evidence, things that you're going to be able to see. You're going to see the video of that incident from start to finish. Things that you're going to be able to hear. You're going to hear the defendant's statements. Things that you're going to be able to take back with you to that jury room when you deliberate. Feel and touch the gun, his holster that he was wearing that day. All those type of things. And we're going to do it by way of testimony. Ladies and gentlemen, witnesses are going to come into this courtroom, they're going to sit right here, and they're going to take an oath. Now, our goal in this trial, believe it or not, our goal in this trial is twofold. 1, to ensure that Mr. Drejka receives a fair trial. He is presumed innocent by each and every one of you. But at the close of this trial, we're going to ask that you take that presumption away. But he, like anyone that walks into a courtroom in our country, wants a fair trial. And we're going to ensure that. The second thing we want to make sure, by way of the testimony, by way of the evidence, is that you have an opportunity to almost be there, to see exactly what happened, so you can make the decision in this case. You are the judges of the facts of the evidence in this case. The close of this trial, the judge is going to give you the law, and you're to apply that law to that evidence. And we're confident you'll do that. And what you're going to learn by the way of the witness testimony. And first you got to start, let's go chronologically. You got to start on that Valentine's Day. A young African-American male was working, Rick Kelly. He was working for a septic tank company. That septic tank company's offices were right around the corner from this convenience store. The convenience store was on the corner of Sunset Boulevard and Douglas Avenue in Clearwater. That business was right around the corner. Rick Kelly's going to testify to you. He's going to tell you since he was a little boy he went to that convenience store. He'd always go into that convenience store. He had such a relationship with the owner of that convenience store, he could pick up items and pay at the end of the week, pick up items and say, Ali, I've got such and such. And at the end of the week, he'd pay for the items. So on this particular day, Mr. Kelly was at work. He's been working at the septic tank company for some time. He was finishing up for the day. It was a hot day, and he was going to run into the convenience store and grab himself a soda to drink. And that's what he did. Matter of fact, he left his tanker truck running. And this is a big, big tanker truck. He left the tanker truck running. And in the front seat of that tanker truck, he had money. Because what he would do is go to the accounts and empty out septic tanks or fix septic tanks and do that type of thing. And then people would pay him by cash or by check. And he would keep all that money in the front seat of his compartment there in that truck. He left the truck running because he was going to just run in and run out. And matter of fact, he ran in, picked up a soda, said, Ali, I got a soda. Didn't even go to the register with it. And then when he went outside, he saw a man, the defendant. He saw this man right here. And he saw the defendant walking around his truck, peeking in the windows, taking out his phone and taking pictures of his truck. And he's like, whoa, what are you doing around my truck? Remember, he has money in that truck. He has checks in that truck. That truck was running. What are you doing around my truck? Get away from my truck, sir. Are you handicapped? No? Are you? That doesn't matter. Well, are you with somebody that's handicapped? That doesn't matter. What are you doing parking here? And then a confrontation started. An argument started. It got heated. Curse words were used. It got heated. It got loud. At one point in time, Mr. Drejka went over to his truck, went into the truck and came back out. It got so loud that the store owner, Mr. Ali Salas, he's the owner-operator of that convenience store. He works 7 days a week. Every day he works. Morning shifts. And he heard the argument because it was so loud. And he went outside and he tried to calm down the situation. And Ricky, who he knows, said, all right, I'm leaving. Ricky said, I'm leaving. But before Ricky left, the defendant made a threat to Ricky Kelly. He said, I could shoot you. I could blow your head off. Ricky was a little upset. Ricky thought he might have to get physical, but he didn't. He got into his car. Back, I'm sorry.
Your Honor, I must object. If we could approach.
Okay. Schaub, you may proceed.
So he threatened him with a gun. Now, Mr. Kelly's going to tell you he never saw a gun. He never saw a gun whatsoever. But Mr. Kelly had one more thing to do for work, so he got into his truck and he left the location. And he was going to go empty out the septic tank over in Dunedin at a facility there. So he had one more thing to do. On that drive, he had a phone call from the owner of his business. The owner of his business is John Tyler, and he's going to testify to you. Mr. Tyler's going to tell you he received a voice message on his phone from the defendant. The defendant was upset about his employee, Rick Kelly. Mr. Tyler was going to call him back, but he wanted to find out what it was all about. He called Mr. Kelly, he found out what it was all about, and then you're going to hear about the phone call that he had with the defendant. Listen carefully to Mr. Tyler. Because Mr. Tyler called him, he said he was, Drejka, the defendant, said he was angry and he was upset about the parking that his employee did. Mr. Tyler asked him, are you handicapped? I'm sorry. He said, no. Well, were you with somebody that's handicapped? No. All right, well, I apologize. It got heated to a point where he said he's lucky I wasn't carrying because I could have shot him. He said that to Mr. Tyler. Mr. Tyler, carrying the concealed weapon permit holder, said this conversation's not going anywhere. You mean you can shoot someone over a parking spot? And he terminated the phone call. But before he did, he said, go ahead, you can call the police. I'll talk to them if I need to. Remember I said that that argument got loud. Mr. Salas, the owner, heard that argument. And he went outside and he checked it out, calmed it down, had Ricky drive off. Then he had a conversation with the defendant. And this is important because his conversation as that owner of that business, he said, you need to knock it off. You need to stop this behavior. It's not worth it. Mr. Drejka acknowledged that he knows it's wrong, but he can't help himself. It always gets him in trouble. Now, we need to go forward. Oh, let me talk about another witness you're going to hear. From Nelson DeLeon, detective, the Pinellas County Sheriff's Office. And he's going to tell you how he came about finding out about this incident. And listen carefully to what he tells you. Because when Ricky, on that day of the incident, now we're going to go forward, all right? We're going to go forward to July 19th of last year. 5 months later, on July 19th, Markeis McGlockton was killed at that convenience store. Ricky was working AAA 7. He walked by, he noticed a vehicle in that parking lot, a silver SUV. He remembered that silver SUV because that silver SUV had been the car driven by the defendant in the altercation in February. He went and told his boss. He did not want to get involved. His boss kind of guilted him to get involved. Said, you got to tell them what you know about that car and the operator of that car. So he walked over to the scene. Law enforcement was there, tape was up, Detective DeLeon was there. And he walked up to Detective DeLeon and said, is this car involved in anything? He didn't know what had taken place. He didn't know if a shooting had occurred. He didn't know if what had occurred. He didn't know who was the victim. He didn't know if the victim was a female, if the victim was a male, if the victim was white, Asian, African American, or what. He had no idea. Detective DeLeon said, well, I don't know. All the cars are important. Why? What do you know about the car? He told him the story of what had happened a couple months earlier at that same convenience store. And you're going to hear about that. He had no agenda. He told him what happened on that day on July 19th. Now, let's talk about July 19th. July 19th was a typical day for Markeis McGlockton. 28 years old. Father of 3, had a baby on its way. Markeis lives with Brittany Jacobs. That's his partner. They've been together for 10 years. They were high school sweethearts. They went to Dunedin High. She was 3
Your
years
Honor, I
younger.
object if we could approach.
Okay.
Markeis worked during the night at the 7-Eleven located on Drew Street in Clearwater. He worked during the day, watched the kids, they lived together. Brittany Jacobs would work during the day while he watched the kids. Brittany worked at East Bay Rehab Center, caring for the elderly, people with dementia.
Your Honor, again, relevance.
All right. Overruled.
That's what she does. That was her job. She was a certified nursing assistant working at East Bay Rehab Center. That's where she was that day. She worked from 7 to 3. She got off work at 3 o'clock. Markeis picks her up, just like he always does. He had the 3 kids in the car. He picks her up, she decides to drive, she drives, and stops at the Circle A convenience store. Now you're gonna hear her family grew up around the Circle K. Markeis's family lived around the Circle K. They've been to the Circle A convenience store. Brittany pulls up. She parks in a handicapped parking spot. We're not gonna say that's right. It's not. But she parks in a handicapped parking spot. Markeis has his two kids in the car, and he's gonna run in to grab some sodas and some candy or food for the kids, and some snacks. And you're gonna see the car pull up, park into that spot, and you're gonna see Markeis get out of that car with Markeis Jr., the 5-year-old, and he walks with that child inside the store. And you're gonna see him inside the store. And you're gonna see him walk inside the store and even go to the cash register. But while he's doing that, there's something going on out in that parking lot. And it's the defendant. And he confronts Brittany Jacobs. and he starts in about her parking in a handicapped spot. But watch, because you're going to be able to see this. Watch what he does when he goes into that, when he approaches that car. He parks his car, he gets out, he walks around that car, peeking in the windows of her car, walks to the back of the car, the front of her car, looking in the windows. She's concerned. She's by herself. She has 2 young babies in the car. And here's some crazy guy walking around the car.
Objection, Your Honor.
All right, overruled.
Here's some guy walking around her car that she has never met before. And he starts in out. And this is ironic. Look at this video. Look where he's parked. He's not parked legally. He's parked not even in a spot. He pulls up in a non-parking spot to complain about her parking. Look at that. Look at that video. He's not parked legally. He complains about her parking. Are you handicapped? What's it to you? Are you, in and in? Arguing, cursing, the whole 9 yards goes on. Meanwhile, you're going to see on that video, you're going to see people walking into that store. People coming in. Now remember, it's broad daylight, in the middle of the day. And people are walking in and out of that convenience store. Look at the people that walk in and out of that convenience store. Watch them very carefully. Look at them. You're going to see them. They all look in that direction. They all look over at that confrontation because it's loud, because he's arguing with this young female. It gets their attention. Matter of fact, Mr. Robert Costelli, a witness in this case, pulled in. And you're going to hear it caught his attention, and he's going to tell you he was concerned. He thought about going over and interjecting himself, but he didn't. Instead, he listened for a while, and then you're going to hear he went to the front door, and he told the store owner in there, and you're going to see this on video. Markeis is right there with Markeis Jr. at that store, getting ready to buy his stuff. Mr. Costelli comes to the door, and Mr. Costelli says, there's a problem out here in the parking lot. There's a problem out here. I think you better do something. Markeis heard that. You're going to see him put down the items, leave Markeis Jr. inside the store, walk out, and you're going to see him walk out and walk up to where Mr. Drejka was. This is the view that Mr. McGlockton had. And you're going to see it on videotape. These are still photos of that. When he walks out of that store. 1 foot away from her window, from the mother of his children's window, from the 2 babies in that car, he was right there, finger pointing, wagging his finger at her. He heard there was a problem out there. You bet he went out to defend his family. And when he got out there, he pushed him away from that car and pushed him down. And did he push him hard? Yes. Pushed him down away from his family. He heard there was a problem out there. He saw there was a problem out there. And he pushed that person away from his family. And that's when the problem happened. Because after he did that, Mr. Drejka pulled out his gun. He was carrying a gun on a holster. He pulled out his gun. He was on the ground. He pointed that gun directly at Mr. McGlockton. And watch carefully. We're going to show you a slow motion video, a portion of that. When he waves Mr. McGlockton over, Mr. McGlockton backs up. Mr. McGlockton backs up as far as he can go, all the way to the car. He can't go back any further, and watch that video. He starts to turn away from the confrontation. And he's shot at that time. Matter of fact, the video speaks better than I can. backs up, turns, shot. After he's shot, he heads back into the store and falls on the ground and dies in that store. You're going to see that videotape numerous times during the course of this trial. You're going to see still shots taken from that videotape. After this occurred, the defendant was interviewed. The defendant was talked to by law enforcement. Listen real carefully to that interview. It's about an hour long. Listen real carefully to that interview. The defendant uses these military law enforcement terms. He's not in the military. He's not in law enforcement. He's 47 years old, and he's been retired for many, many years. Says he came into some money from his mother died, and he was retired, I think, in 2006 or something, 2003. And he talks about that on the video. Not in law enforcement, not in the military. Listen to what he says. He starts talking about a thing called the 21-foot rule. Actually, I think today it may be a 25-foot rule. But what that rule is, Scott, take it off. What that rule is, ladies and gentlemen, is plain and simple. If a law enforcement officer is 21 foot away from a suspect, and that suspect has a blunt instrument, a sharp-edged instrument, a knife, a hatchet, and that officer hasn't drawn his weapon yet, by the time that officer can draw his weapon, pull it out, aim, and shoot, he needs to do it. Because in 21 foot, that person can close that gap with that sharp-edged object. And why is that important? Because in this case, we have no sharp-edged object. You're going to hear that Mr. McGlockton was unarmed. No knife, no gun, no weapon of any kind on his person. He was unarmed. The 21-foot rule does not apply to an unarmed man. And you're going to hear that during the course of this trial by way of expert testimony. And I'll talk about that in a moment. He also uses a term called force multiplier, as though that justified the situation. Force multiplier can mean numerous things. One of the things, I think, it's kind of a military term perhaps, where if they have an army of 100, you better have an army of 200. If somebody has one tank, you better have two. If somebody has a knife, you better have a gun. If somebody has a gun, you better have two guns. That type of scenario. In this case, Mr. McGlockton had no weapon. The 21-foot rule didn't apply also because that situation, the gun was already out. In the situation you saw, and watch his hand, watch it move. In the situation you saw, that controlled the situation. Ended. It's over. No, he took the life. Watch carefully him backing up. Watch carefully him turning to the side. You know, you're going to hear testimony from the medical examiner, Dr. Noel Palmer. And we're going to show you photos, specifically the entry wound and the exit wound. And he's hit on the side. Right here on the side. And the exit wound, the slug didn't actually come all the way out, but came right to the surface and caused a bruise indentation. So you can see the exit wound. The exit wound was up on the side. He was turning. He wasn't shot head on. That interview we want you to listen to. Listen real carefully. He talks about the 21-foot rule. He talks about force multiplier. He indicates Mr. McGlockton never said one word. Never said one word. He indicates Brittany Jacobs during the argument said something about, you want me to get my man. And I think she acknowledges that, since she said that. You want me to get my man. But he says not one word. Mr. McGlockton never said anything. They had no words exchanged. Mr. Drejka never said anything like stop. Never said anything. Listen carefully to that interview. He indicates that he didn't even see Mr. McGlockton's hands. He never saw his hands. He shot this man, you're going to learn, without having even observed his hands. He never saw his face. He shot this man without even looking at his face. All he saw was his feet. All he saw was his legs. He knew he was an African American based upon the man wearing shorts and based upon the lower body. Listen carefully, because what he says is the defendant was running after he shoved me, and I pulled my gun out and I pointed it at him. He was running towards me. The detective says, well, what if I tell you I watched the video and I didn't see that? So I'm backing up. And his response is, well, I say it's wrong. The video is wrong. No doubt about it. He was running out. I saw him twitch. Watch that video. In that interview, he was asked, aren't you concerned about going up to people, confronting people? You don't know them. Don't you think it might, that type of a confrontation might scare somebody? You don't know what, you don't know what that person, who that other person is, what might happen. You know what he says? He says, I'm not concerned. I'm not concerned. Because I'm always carrying it. I said, you're always carrying it. Since I was 20, 21, I'm always carrying it. Listen to that. They asked him in that interview, wouldn't the thing to do call the police? I mean, somebody parks in a handicapped spot. He says, that's my pet peeve. That's my pet peeve. And that's fine. I understand that. That's my pet peeve. And he's asked, well, don't you think it would be smart to maybe call law enforcement? Well, by the time you get there, I mean, they're going to be gone. So, all right. That's kind of what we want. Then leave the spot. No, he wants to confront that person. Listen carefully to his statements. So we're going to play that for you. It's about an hour long. And then the detectives even have him demonstrate, when he was on the ground, how far Mr. McGlockton was from him when he shot. Watch it. Look at it. He goes, oh, back up, back up. The detective backs up. Further? Yeah, further. The detective hits the wall. He says, I can't go back any further. Well, we're going to show you exactly the size of that room. It was 9 by 11. It was a 9 by 11 room. We measured it. And you're going to see that that was a 9 by 11 room, and he backed that detective up all the way to the wall. And that's when he said, he then started running towards me. We're going to play that for you. We want you to listen to that. We want you to listen to everything. We're going to show you photographs. Photographs of the defendant's body. Without his shirt, his legs, his arms, his hands, everything. He had one injury, and that was a burn from the asphalt when he was knocked down on his shoulder. No injuries, no marks, back of the head, front, every possible position. And you're going to see the one injury there on his shoulder area. You'll see those photographs. Now, I told you you're going to hear the testimony from the medical examiner. He's going to talk about and show you and demonstrate with charts and all that the entrance wound and the exit wound and where it exactly was on the body. The cause of death was one shot by gunshot. The manner was homicide. And you're going to see that and hear from Dr. Noel Palmer. Now, a toxicology report was done, always done on autopsies. There was a drug in Markeis' system. It was MDMA, ecstasy. We've got an expert from the University of Florida, head of the toxicology department at the University of Florida, Dr. Bruce Goldberger, who's going to come in this testify about MDMA, what it is, what ecstasy is, what are the effects. And what you're gonna learn that it is not a factor in this case. That's what the evidence is going to show. It's not a factor based on the amount in his system and the type of drug that ecstasy is. Dr. Goldberger is gonna tell you it's called the love drug. Kind of makes you sensual. It doesn't lead to aggressive behavior. But, all right, you don't need to take Dr. Goldberger's word for that. Watch the video. Watch the video. Markeis walks out calmly, doesn't run, walks out, sees that, pushes him down, sees the gun, recognizes the gun, backs up. You're going to hear from Dr. Bruce Goldberg. You're also going to hear from Roy Bedard. Roy Bedard is, I think it's fair to say, a world-renowned expert in the area of use of force. He consults on television shows, police shows. He wrote the book that Florida Department of Law Enforcement created on use of force. He's from Tallahassee. I think he's got his doctorate today. He has his issues. Then he's going to talk to you about the use of force and what that means. He's also going to talk to you about the 21-foot rule and how it just doesn't apply in this case. He's going to mention to you about force multiplication, force multiplier, excuse me. Whereas some people call it a force continuum. He's going to tell you about that and how it really doesn't apply in this case. So you're going to hear from Roy Bedard. He's coming in from Tallahassee. We're going to present his testimony to you. He's a use of force expert. Listen carefully to his testimony. At the close of this trial, and you don't get me wrong, a couple things. That incident that occurred on February 14th, that's no reason why you convict the defendant. That just goes to show intent. That just goes to show his opportunity. What we're on trial for today is what he did to Markeis McGlockton. What he did that was improper. The taking of a human being's life without any legal justification. That's why we're in this court. That's what this is all about. And he is presumed innocent. And you all need to honor that. He's presumed innocent. And that's the way our system works. He's presumed innocent until the time you hear the law, and you hear the evidence, and you see the evidence. And at that time, you go back into that jury room and you begin to deliberate. And it's at that time you can take the presumption of innocence. And we want you all to take your time and look at the evidence and weigh that evidence and listen to the law that Judge Pallone gives you. And then return to this courtroom with a verdict that speaks the truth, a verdict that says, we, the members of the jury, each and every one of us, finds the defendant guilty of the crime of manslaughter. So say we all, each and every one of us.
Thank you, Mr. Schaub. And Mr. Camarino, you may proceed with your opening
May we
statement.
approach for a second?
You may.
Thank you, Judge. May it please the court, members of the jury.
The 11 seconds that it took for me to walk from my desk to this podium is the time span that happened from the time that Mr. Markeis McGlockton exited that store, push up Mr. Drejka, and was shot. 11 seconds is all that took. And so I think it's important that when the state tells you, look at that video, absolutely, I'm gonna play it in a second. We want you to look at the video. We want you to look at it in real time. We don't want you to look at it in slow motion. Because life doesn't happen in slow motion. Life didn't happen in slow motion for Mr. Drejka. Now there are things that you're going to see in that video, but there are things that you can't hear in that video, but that happen. Things that come into play or came into play when Mr. Drejka took the action that he did in those 11 seconds. And even within those 11 seconds, members of the jury, even within those 11 seconds, it took about 5 seconds roughly for Mr. McGlockton to push Mr. Drejka, and then another maybe 3 to 4 seconds before the discharge begun. 11 seconds. And while Mr. McGlockton, may he rest in peace, had no weapon, he was the weapon. He was the weapon. The judge is going to read you an instruction on homicide, on manslaughter. When you hear the term homicide, it means death as opposed to, let's say, suicide. It's a technical term, medical term, just the opposite of homicide. I'm sorry, opposite of suicide. Specifically, he is charged with manslaughter. As Mr. Schaub pointed out, it's not first-degree murder where he premeditated this. So when you hear about this February event, I would submit to you, one, the February event is not a crime. Not a crime. He wasn't even charged with that incident. Wasn't even arrested for that incident. In fact, Mr. Richie Kelly didn't even bother calling the police for that incident. I'll get to Mr. Richie Kelly's testimony in a little bit. So, there's no premeditation, so not first-degree murder. No second-degree murder, no ill will. There's no evidence of ill will. No evidence of ill will. No evidence of hatred. And no evidence of spite. Because that would have been the element for second-degree murder. He's not, Mr. Drejka is not on trial for having ill will, hatred, or spite, or premeditation. So that February event, I submit to you, is not even a crime, and the judge will even tell you he's not on trial for that crime. The state wants you to hear that testimony, hear this idea that this was something planned. Something that he planned apparently months ago, meaning Mr. Drejka. Couldn't wait for this to happen. We want you to look at the video, but when we look at it, Mr. Drejka, I want you to look at it in real time. I'm going to play it for a second. Go ahead, Mr. Drejka. From there. 11 seconds. Stop. Now, what I think is important to the jury is that when the judge reads you the definition of manslaughter, the judge is going to read you the definition, and just bear with me, that there are exceptions. It's an unjustified homicide. Unjustified is the key word. And the judge will tell you, though, there are, within the law, and as the fact finder, we're going to get to what your role as the fact finder means and why it is so important that you listen to these witnesses. Listen to what they say today, but listen to what they also said back then. And as you folks weigh the credibility of these witnesses, if they've changed their story, that's something that you can go back and go take into consideration is, if we're here to find out the truth, why are witnesses changing their story today? I submit to you, we'll get to that in a minute, but I'll submit to you, there'll be plenty of instances where these witnesses are changing their story to fit the crime that didn't happen. The judge will tell you that there are, within the definition of this manslaughter, the unjustified killing of another person, there are exceptions. There's justifiable homicide. That's a defense, so to speak. Justifiable is when a person reacts to defend themselves, short of self-defense, we'll get that in a minute, to prevent something like a felony being committed upon them. The judge will also tell you there's what's known as excusable homicide. Excusable is when someone reacts heat of passion, sudden provocation. The judge will read you that law. And that's why it's important when you read or you listen to the testimony of these witnesses, you'll see that there was sudden provocation on the part of Mr. McGlockton. The judge will also tell you that self-defense is a law that's been in place forever. And and you folks can take that into consideration. When you listen to the facts, and when you look at it. More importantly, the judge will tell you that you have to look at what were the circumstances that surrounded Mr. Drejka at the time this happened. In 11 seconds, this happened. In 11 seconds, you'll hear testimony. This is Mrs. Britany Jacobs right here, coming out of her vehicle. This is Mr. Costelli, and that's Mr. McGlockton. It's important, members of the jury, that when you look at this, remember, it took about 6 seconds from the time that Mr. McGlockton exited the store and pushed Mr. Drejka. 6 seconds after. And play it. And stop. Now, what you're going to hear is this, that prior to Mr. McGlockton coming out, Mr. Costelli, the gentleman that you see coming out of the store with the blue shirt and the red sneakers, you're going to hear that he did hear the altercation. It was a verbal altercation. But what's important is you're not going to hear Mr. Costelli say that Mr. Drejka was threatening anybody. No matter what Mr. Schaub or the state says, there was no threats. Mr. Drejka had a concealed weapon. He was allowed to have a concealed weapon. Not once did he ever take that weapon out or threaten anybody. Not once. Never threatened. Britany Jacobs was in the car. Never said anything to cause any fear in her mind. Nothing. In fact, you will hear that at some point, Ms. Jacobs said to law enforcement when all this was said and done that she couldn't wait to get out of that car. She was going to lay her hands on Mr. Drejka too. She couldn't wait to get out of the car. And if you look, who opens the door the minute she sees Mr. McGlockton come out? Britany Jacobs. Prior to that, Mr. Costelli will tell you at some point in the past, Mr. Costelli told during an interview, if you will, deposition, that he specifically heard Ms. Jacobs say, "My man is going to F you up." Wait, because my man is about to F you up. So when you hear Mr. Schaub say there was a verbal altercation, absolutely there was a verbal altercation. But not once did Mr. Drejka threaten him or her, threaten the kids. There were kids in the car. We want you to rely not on emotion, but on facts. The facts, the truth. Not once did he threaten anybody, not once. Mr. Costelli will tell you not one word of a threat on the part of Mr. Drejka. He'll tell you, folks, that it was Britany Jacobs who was threatening Mr. Drejka. Wait, my man is going to F you up. Just wait. And no sooner that he comes out of the store, no sooner does he come out of the store, she's in the car, she sees her man, and what does she do? She comes out. Stop. And so, when the judge tells you, you have to put yourself, or not yourself, but when you have to consider all the facts and circumstances that Mr. Drejka was facing at that time, you have to consider that in those 11 seconds, and actually shorter than that, because the push is about to happen, he doesn't see Mr. McGlockton. He doesn't see him at all. He's blindsided. And for Mr. Schaub to say that this was just a push, this was not a push. This was a violent shove. So much so that when he hit the pavement, you'll see, look at this, you'll see it somewhere. Look at Mr. Drejka's neck. The whiplash, the force of the blow, and he landed. Jump ahead a little bit, when you hear that there was a little injury, the force was so strong that it tore a hole in his shirt. And during his interview, law enforcement, during his voluntary interview, law enforcement, he didn't have to give. He had to make a makeshift sling because he had hurt his arm. So at this point, this is a perfect stop right here. So at this point, when the judge tells you, you have to look at the facts and the circumstances that surrounded Mr. Drejka at the time that he reacted. At this point, 1, 2, 3 people are hovering over Mr. Drejka. 3 people. You have the threat that my man is going to F you up. You have her exiting the car, and then you have this sudden shove, this sudden push that caused him to hit that concrete hard. And looming in the background is Mr. Costelli. And in that instant, in the bout, remember, from the time of the push to the time that the gun was withdrawn and discharged, it's about 3 to 4 seconds. 3 to 4 seconds before the discharge took place. And within those 3 to 4 seconds, Mr. Drejka, in his mind, what is about to happen to me? That I see Ms. Jacobs come out, I've been blindsided and shoved, I see a gentleman looming in the background, and I see Mr. McGlockton lifting up his pants. I submit to you, I'm impressed. And that's how they proceed. So when you hear all this, absolutely, take all this into consideration. But let's get to the truth. Let's get to the truth of what happened. 11 seconds, Mr. Jury. That's all it took. And unfortunately, the action Mr. McGlockton took resulted in this. I'm not blaming here to assign blame. I'm here to explain. There's justifiable homicide, there's excusable homicide, and then there's self-defense. Those are the facts that we want you to hear. Here's plan, please. Shooting happens. Mr. Castelli walks away. Mr. McGlockton goes in the store. Mr. Drejka sits there. He pauses. He goes on for a few more seconds after that. He pauses. He puts his gun down. What does he do? He waits. He doesn't run. He doesn't flee. He waits. What does he wait for? Just for the police. He waited for the police, and he told them what happened. Now, at some point, this is the danger when you talk to the police, is that anything you say can and will be used against you, no matter what you say. So in this instance, because he said, go back, go back, go back, it's not like Mr. Drejka took a measuring tape and measured it before he interviewed the police. At the time he was interviewed with the police, he had a makeshift arm sling. He's giving law enforcement his best recollection of what happened. So when the police are coming here and tell you, he said, go back, to the point where law enforcement couldn't go back anymore, and it was happened to be 9, 10 feet, does that make it so? Or is that just Mr. Drejka's best interpretation of what he would call happened? When Mr. Drejka tells you that in the 2 seconds, 3 or 4 seconds that it took for him to shoot the gun, that in his perception he saw Mr. McGlockton come after him, is he lying? You will hear testimony that Mr. Drejka went into the store and asked, are there cameras, are there cameras, are there cameras? This is immediately after the shooting, because he knew the owners as well. Are there cameras, are there cameras, are there cameras? Yeah, there's cameras. He knew there was cameras inside that store. So he wasn't lying. He was remembering the best that he could for the impact that he sustained. It's important to point out that the state made a big point that he himself didn't park in the spot. Certainly, though, you'll see that this photograph was taken almost immediately after the incident, and Ms. Jacobs' car is no longer there. Somebody moved it. Somebody moved it just before the police got there. But even more importantly, members of the jury, when we look at the setting, the circumstances, you're going to hear from the medical examiner that Mr. McGlockton was slightly taller, a couple inches, maybe a few inches taller, weight heavier. And these are things, again, that the court will take into consideration, the facts, the circumstances, the size, the appearance of the aggression that he was faced with that caused him to react the way he did. But the other advantage that Mr. McGlockton had at that moment was that, not in addition to the height, that he was a height difference. Mr. Drejka was sitting on lower ground, and Mr. McGlockton had higher ground. And these were all the factors that came into play at the time the incident happened. I mentioned the witness credibility. It's important. It is. The judge will tell you that the presumption of innocence does stay. It's up to the state to disprove. It's up to the state to prove that it wasn't justifiable through the same witnesses. It's up to the state to prove to you that it wasn't excusable. And it's up to the state to prove that it wasn't self-defense. We don't have any burden here, and I have to remind you of that. We have no burden, no responsibility. But in order for the state to do that, you have this awesome power to believe or disbelieve these witnesses. That's why when Mr. Schaub says, listen carefully to his interview, absolutely listen carefully to his interview. The one that he didn't have to give, the one he gave what they call after his wife. Listen to what Ms. Jacobs has to say today. To compare it to what she told law enforcement that day. That she got out of that car for a reason, not because she was in fear. Because she couldn't wait to get her hands on him as well. And that's the sentiment that was conveyed to Mr. Drejka. It created this apprehension of fear. A reasonable apprehension of fear. Coupled with a threat. Wait till my man comes out. Coupled by the sudden violent push. And then this gentleman, Mr. Castelli, looming in the background. 4 seconds, member of the jury. 4 seconds. That's why there's no premeditation. That's why there's no ill will, hatred, and spite. Because it was 4 seconds. 4 seconds, circumstances by which Mr. Drejka felt that something was going to happen. And what's important, members of the jury, is at some point the judge will tell you that the danger need not have been actual. The danger need not even have been actual in his state of mind. It's the appearance of danger you take notes, take this note. You don't have to, but just, the danger need not even be actual. It's the appearance of danger that can cause him to act justifiably, excusably, or in self-defense. That's what's at issue here. So look at the video, listen to the testimony, and put it all together. Let's talk about Richard Kelly now that I mentioned. And as I mentioned, members of the jury, as far as the slow motion, members of the jury, state's gonna play whatever version they want. Life didn't happen in slow motion. I want you to look at it in real time. Count the number of seconds. Play it in slow motion if you want. That's not how it happened to Mr. Drejka. Going back a little bit, put the circumstances kind of into context. It may have been Mr. Drejka's pet peeve that somebody was parking in a handicap spot. That's not a crime. We heard from members of the jury yesterday, this week, that said the same thing. It's a personal issue to Mr. Drejka to have someone park in a handicap spot. That's not a crime. In fact, Mr. Schaub told you perhaps it was wrong for them to park in that spot. And that's all Mr. Drejka did. So in your testimony about him looking around behind the car, you'll see what he's doing. He's looking for a handicap tag. That's all he's doing. So if there are any allegations that, well, Mr. Drejka felt threatened, you can hear testimony, he didn't even know they were there inside the car. One, he had glasses on, and two, the windows were tinted. He had no idea who was in the car. He's looking for a tag in the rear, goes up front, looks for a tag up front, doesn't find anything. And at some point, you'll see that the window rolls down, and it's Mr. Jacobs who initiates the contact, initiates the aggression. He went downhill from there. That is the fact. Those are the facts. That's the truth by which you need to go back and determine whether or not a crime has been committed. You can see my style is a little bit more deliberate. I'm not going to rely on emotion. Because this is important. We're not driven by emotion, politics. We're driven by the facts. So bear with me if I take the time to look at my notes, but this is important. And as fact finders, the judge would expect the same of you. No emotion, just the facts. You will hear that there were other people there. Again, the state has the sole burden of proving guilt beyond a reasonable doubt. There were other people there, and they were absolutely watching and observing what had happened. And quite frankly, you'll see that Mr. Costelli was there. You heard he went into the store. And we'll find out maybe what was his rationale for walking. What was his deal? Why was he going out and approaching this altercation, if you will? There was a young lady by the name of Britany Hicks. She was there. In fact, I think you may see her in the video. She may have been one of the young ladies that looked back, saw that there was an argument going on, but went on her way. Not enough. She didn't see anything that caused her enough to really say something bad's going to happen. It really was just a verbal dispute. And the person who initiated the violent contact, the person who conceded didn't have a knife, didn't have a gun, the person who had the force, the weight, he didn't walk over to Mr. McGlockton. He made a beeline to Mr. Drejka. He made a beeline towards him. He forcibly pushed him. He initiated the violence. Talk about Richard Kelly. This incident happened in February of the year before. What's interesting again is the state's going to tell you, well, he's not charged with that, it's not a crime, and it's not. The judge's going to tell you, he's not charged with that. But you can kind of take that into consideration to see whether there was a motive, plan, something that going on and working in the mind of Mr. Drejka. Well, members of the jury, again, it's not a crime as to what happened back in February. It wasn't a crime. The police were never called. Mr. Drejka was never charged. And so if the state's not going to argue this is premeditation, which it's not, then what's the point of listening to this story? You have to rely on the evidence and the facts that I submit you happened that day. Now, Mr. Kelly is going to tell you that this altercation happened, and that what did he see Mr. Drejka do? Take pictures. Take pictures of this company vehicle parked in a handicap spot. And what did Mr. Drejka do? He didn't pull out a gun. There's no violence. They're claiming that the statement was made, I could have blown his head off, I'm sure. again, that's not charged with a crime, wasn't a crime then, no police were called, despite the fact that they want you to believe that he threatened to shoot him. No police were called. What did Mr. Drejka do? He called management. He called the company to say, hey, you're parking in a handicap spot. My pet peeve, folks, my pet peeve. And that's all he did, was he called the company. So take a look at Mr. Kelly's testimony, because you're gonna hear that coincidentally, he happened to drive by, he saw the car, and he's gonna tell you, from what I gather, opening statements, that he didn't know who was shot, who was killed, he didn't know anything about that, just happened to recognize the car, happened to be at the right time, right place, right time, spoke to law enforcement, Detective DeLeon, said, hey, I recognize that car, and this is what happened 4 months ago, 5 months ago. And then that led to his boss, John Tyler, potentially becoming a witness, but then you're gonna hear that Mr. Kelly himself participated in rallies against Mr. Drejka, joined his community to go out there and fight to see that he's convicted. And the judge is going to tell you, you have that right to look at what's the incentive for witnesses to come in here and say what they're going to say. And so this Mr. Kelly, who was out there fighting for the conviction of Mr. Drejka, is out there rallying the people. He's going to come in and tell you about an incident that happened where he didn't call the police. Important. If we could look at the video one more time, Mr. Flores. By the way, while he's preparing that, unfortunately, that day there was you're gonna hear there's testimony that Mr. McGlockton did have what's commonly known as ecstasy or LSD in the system. And you're gonna hear from their witness, you're gonna hear from their expert witness that what he, in his expert opinion, believes ecstasy, the effect that could have on a person. But you're also going to hear from their own expert that ecstasy can cause impulsivity. Their own expert's going to tell you that he didn't know Mr. McGlockton, doesn't know how long Mr. McGlockton may have been using LSD, doesn't know anything about that, doesn't know how much he took that day. But he'll tell you, their own witness, and you may even hear from a witness of ours, that yes.
Your Honor, I'd object. There's no testimony or evidence about LSD in this case.
Yeah, I think you may have said that
I'm
by accident, so I'll sustain the objection. All right.
Ecstasy, I'll just wait, I apologize, not LSD, different drug completely. I'm a little older, I apologize. Ecstasy for short, okay. Point is, you can hear their own experts gonna say that ecstasy can lead to the impulsivity that's submitted to you. You witness the cause of violently push. And that's evidence. But you're allowed to take that back there with you. And consider that when you deliver it. Let's talk about this. Okay, so now there's testimony that within the time that Mr. Drejka removed the gun, and it took about 2 to 4 seconds, 4 seconds at best, at most, that he was directing Mr. McGlockton, directing him, and then he discharged. But remember though, we're talking 4 seconds, we're talking about, and again, if you look at the video, we're talking about the shock, the whiplash, if you will, before it ended. The shock, and at some point you're gonna hear from Valerie McLean, who can tell you that usually when someone's confronted with that type of violence, usually your reaction is one of shock, especially when you don't expect it coming. A blow like that, there's one of shock, disorientation, confusion. That's what's important, that they won't discuss, the state won't discuss. There was confusion on the part of Mr. Drejka. He had no idea what had just happened to him. Look at the video, he had no clue that he was gonna get slammed the way he did and then collide with the floor. And we've heard it before, during the jury selection, it causes confusion. You don't realize what's happened to you. So when there's testimony that he took the gun and started directing people, I submit you, common sense will tell you, and the evidence will show, it's a little bit of everything, a little bit of confusion, shock, because again, when you see that the shooting's done, at the end of that video, he sits there. Mr. Drejka just sits there. The same position you see when discharged, and just sits there. I submit to you, in that same state of shock. So this idea of going back to see that he was directing him, first of all, you'll see that the quality of the video is not good. Stop, can you rewind it? All right, I want you to look at, you're gonna see Mr. McGlockton exit the store. If you can, look over his right shoulder and you'll see there's some static, because everyone will agree that this is not the best high quality video. All right, push play. Look over his right shoulder. You can see some static, wait again. Some static, you can see the hat. And so at some point you'll see, I don't know if you see it with his right shoulder. At some point when you see the gun where they're claiming that he's directing someone, you can't rely on what you see in the video, because that video unfortunately is not the best quality video. You'll see in other instances the grill of the vehicle, the static, you can look at it in your own time, the static, it makes things look like they're moving when they're not. You just stop, okay. So when the state says that they're watching this, I submit to you, it's a combination of the shock, the nervousness, and this poor quality video. No one's gonna ever tell you that on that day, the day of the shooting, that they saw him directing. No one said that. No one's gonna say that they saw that happen. There was no time for Mr. Drejka to contemplate that, to say, move. In fact, nothing was even said. And again, remember this whole idea that, well, he saw the legs up. Patel was an African-American person. We get it. It's not about race, but we get it. You gotta make it a point. You recognize an African-American male. It's not what happened. It's not what this is about. But nonetheless, for them to sit there and say that all you can see, and yet he claims he learned that, remember, it's not been that quick. That quick. There's no time for him to contemplate, to direct anyone. Look at the video, you'll see it's a combination of poor quality video and nervousness. And the time he's confronted with what you see there, the three people moving in the back.
All right, you can stop it. I'm going to sum it up this way, members of the jury. Actually, if I have a moment, Judge, I'm sorry.
You may.
All right, so, and I promise I'm gonna wrap up, but one of the things that, again, I want you to listen carefully to the witnesses, just as a simple reminder is, when you go back there as the fact finder, as the truth finder, the judge is gonna tell you that you have to have an abiding conviction of guilt. The judge is gonna tell you that, it's an abiding conviction of guilt. That's how strong the state's burden is. That's how strong it has to be. And that's why I implore you, absolutely listen to the testimony, but more importantly, what are people saying now as opposed to what they said back then? Again, you will hear that at some point, it was Brittany Hicks that at some point may or may not testify, and if she does, she'll tell you that she herself thought that Mr. McGlockton was coming in for another blow, another attack. And again, if you look at that video, at that one point where Mr. McGlockton lifts up his hands and he has his hands up, that is what Mr. Drejka saw. We can't ignore that. The state may want you to, but you can't. Because that's exactly what went on in Mr. Drejka's mind. So Brittany Hicks is going to say, I submit to you, at least she said back then, that she herself thought that Mr. McGlockton was going in for another attack.
All right. Folks, I know you've been very attentive, and I'm just going to wrap up with the following closing remarks. I'm sorry. This is my opening statement. This is not evidence. I want you to remember the rules, so to speak, is that you're the fact finder. Justice is blind. It's not driven by emotion. Politics, race, prejudice, bias. Judge can tell you that doesn't come into play. The facts that they represented that day, the facts that they played in the mind of Mr. Drejka that day. I think it is important that when you hear the testimony of Mr. Kelly, Richie Kelly, keep in mind, and Mr. Tyler, his boss, keep in mind the context of what happened then back in February compared to what happened in July. There was no fight, no physical altercation. Allegedly, words were exchanged where he allegedly, my client allegedly threatened to shoot somebody, although no gun. Listen carefully to the testimony. At some point, Mr. Drejka went to his car, and you heard he took pictures. There's no gun removed that day in February, no gun. There's a difference, there's a complete difference of the two instances that I submit to you really should have no bearing. That's just my argument to you folks. What happened here was unfortunate. What happened here was a gentleman who weighed more, was taller, had the higher ground from the ramp, initiated the contact, and it caused, again, the sense of shock in the mind of Mr. Drejka. I submit to you, the evidence will show that he reacted based on what he observed that day. I submit to you, the evidence will show that the use of deadly force was justifiable, and you're going to hear that term again, excusable, and so on.
Justifiable because, again, Mr. Drejka reasonably believed that force was necessary. And those facts and those circumstances are justifiable. And I also submit to you that his behavior was excusable. The sudden provocation, if you hear the word, sudden provocation, you hear the judge tell you, the sudden provocation that occurred would also rise to the level of excusable homicide. And those are defenses. And it's the state's burden to rebut those and show that it wasn't justifiable or excusable, or the last one, self-defense. Remember, you have to consider everything, the facts and circumstances by which he was surrounded, and I promise I'm going to end with this. When you couple everything you've heard me say, altercation, encounter, the verbal altercation, the fact that not once did Mr. Drejka, when he initiated contact, the fact that he didn't even know that that car was occupied, the fact that he never moved a gun, the fact that it was Britany who initiated the threats and the warning, my man's going to come in if you will.
Your Honor, at this point, the state would object. We're getting into argument now, repeating the same things over during
Judge,
opening
I'll conclude.
arguments.
Thank you, Judge. That the only true and just verdict is that of not guilty. And that's what we're asking for. Thank you. On behalf of Mr. Drejka and my fellow co-counsel, I thank you for your time.
All right. Thank you, Mr. Cameron.
Thank you, Judge.
All right, members of the jury, we've been going for quite a while, so let's go ahead and give you a 10-minute comfort break, and then we'll come back and we'll start with the testimony. All right, so we'll take a 10-minute break.